The balance between executive authority and judicial independence forms a cornerstone of American constitutional governance. When these institutional boundaries face pressure, it raises fundamental questions about democratic checks and balances that protect constitutional order. Welcome back to Politics and Economy USA. Recent developments involving Department of Justice actions against federal judiciary leadership have sparked intense debate about separation of powers and the appropriate limits of executive branch authority over judicial conduct oversight. A comprehensive analysis from legal experts provides crucial context for understanding the constitutional implications of current Justice Department initiatives targeting federal judiciary leadership.
This attack on a federal judge is preposterous. Last week, in a post on social media, Attorney General Pam Bondi announced that the Justice Department filed a misconduct complaint against James Boasberg, the Chief Judge of the Federal District Court in Washington, claiming he made improper public comments about President Trump and his administration. The essence of the complaint is that Judge Boasberg, in talking with John Roberts, the Chief Justice of the Supreme Court, and other federal judges, said things that have undermined the integrity and impartiality of the judiciary, and that as a result he should be subjected to an investigation, temporary reassignment of some of his cases, and potentially public reprimand and consideration of impeachment-related recommendations. The complaint misrepresents both what Judge Boasberg said and the nature of the setting in which he spoke, and it misapplies the law and the rules governing judicial conduct. Worse, it is a dangerous escalation in a mounting list of assaults by the current administration on the legitimacy of the federal courts. It is, in a word, preposterous. According to the complaint, the comments took place on March 11th at a session of the Judicial Conference of the United States, the national policymaking body of the federal courts. In that session, the Justice Department claims, Judge Boasberg, straying from the traditional topics of the conference, expressed his belief that the Trump administration would disregard rulings of federal courts and trigger a constitutional crisis. The Justice Department claims that Judge Boasberg tried to push a wholly unsolicited discussion to persuade the Chief Justice and other federal judges of his preconceived belief that the Trump administration would violate court orders. Apparently, the complaint is based on a leaked memorandum purportedly written by a member of the Judicial Conference. Even if the claims against Judge Boasberg had merit, they don't. The Attorney General's announcement on social media is a violation of the law, which requires confidentiality. The entire exercise is an insult to the federal judiciary and cannot stand. If Judge Boasberg was accurately relaying his colleagues' concerns, the complaint was tellingly silent on this point, then he was providing appropriate feedback to the Chief Justice, not opining on a specific pending matter. The notion that it is somehow improper for judges on lower federal courts to raise a general concern about the prospect of their orders being ignored simply beggars belief. And it turns out that those concerns were well taken. In July, the Washington Post reported that Mr. Trump and his appointees have been accused of flouting courts in a third of the more than 160 lawsuits against the administration in which a judge has issued a substantive ruling. Last week, the Times reported on the Senate confirmation of Emil Bove, a Trump loyalist, as a federal appeals court judge, noting that during his brief tenure as a Justice Department official, Bove was accused by a whistleblower of having suggested that department lawyers might defy court orders.
In a Senate subcommittee hearing, Ms. Bondi seemed to suggest that the administration will follow court orders, but only those of the Supreme Court. Finally, even if Judge Boasberg's comments had been public, even if the comments reflected his views rather than a summary of his colleagues' concerns, and even if those concerns weren't well taken, the Justice Department's complaint doesn't come close to making the case that he violated the Code of Conduct for federal judges. As the complaint notes, Judge Boasberg did later grant a temporary restraining order in JGG v. Trump, but that was a ruling on the specific facts and applicable law in that case, the job of a judge. It doesn't mean he was predisposed to rule against the administration. The real issue here is why Ms. Bondi decided to make such a spectacle out of an obviously frivolous complaint against a highly respected federal district court judge. It seems clear that her first intended audience is other district judges. For them, even frivolous judicial misconduct complaints come at a personal and professional cost, especially when they are filed not by private litigants, but by the Justice Department. If the Chief Judge of the Federal District Court in Washington can come in for such treatment, perhaps other judges will think twice before raising legitimate concerns. The federal judiciary, like Congress, is a co-equal branch of government. Part of its job is to serve as a check on the executive branch. This is so with respect to federal judges across the country, no matter who the appointing president was. Rather than reflecting the lawlessness of the courts, if the complaint against Judge Boasberg is, as it appears, an effort by the Justice Department to baselessly muzzle him, that would be lawlessness coming from the executive branch. The second audience is without doubt Mr. Trump and his supporters. By all appearances, the complaint furthers the idea that presidents can do what they want without a care for federal judicial rulings. That's not how our legal system and constitution work. Ms. Bondi wrote that Judge Boasberg's comments have undermined the integrity of the judiciary, and we will not stand for that. The way to look at this is the inverse. Her Justice Department is attempting to undermine the integrity of the judiciary and the rule of law. This extensive legal analysis, authored by retired Federal District Court Judge Nancy Gertner and Georgetown University Law Center professor Stephen Vladek, provides a comprehensive examination of the constitutional issues at stake in this unprecedented Department of Justice action. The expert's assessment raises several critical concerns about institutional precedent and separation of powers principles. The characterization of the complaint as preposterous reflects broader legal community concerns about appropriate boundaries between executive and judicial branches. The timing and context of Judge Boasberg's comments, occurring during an internal Judicial Conference meeting, highlights important questions about judicial independence and appropriate forums for expressing institutional concerns. The March 11 Judicial Conference represents the normal policymaking process for federal courts, not a public political forum. The legal experts emphasize that concerns about court order compliance proved prophetic, citing Washington Post reporting about administration non-compliance in approximately one-third of over 160 lawsuits involving substantive judicial rulings. This statistical evidence suggests Judge Boasberg's concerns reflected legitimate institutional worries rather than partisan bias. The confirmation of Emil Bove as a federal appeals court judge, despite whistleblower allegations about suggesting department lawyers might defy court orders, adds context to ongoing tensions between executive and judicial branches. These appointment decisions influence long-term institutional relationships and constitutional balance. Attorney General Bondi's suggestion that the administration would only follow Supreme Court orders represents a significant departure from traditional respect for all federal judicial rulings. This position challenges fundamental principles of judicial authority across the federal court system. The legal analysis identifies two primary audiences for the Justice Department complaint: federal judges who might self-censor legitimate concerns and political supporters who favor expanded executive authority over judicial oversight. Both audiences reflect broader constitutional tensions about institutional independence. The expert's conclusion that the Justice Department itself undermines judicial integrity through baseless complaints represents a reversal of traditional accountability frameworks. When the institution responsible for upholding rule of law becomes the source of institutional pressure, it creates fundamental governance challenges. This situation demonstrates how constitutional checks and balances depend on institutional respect and self-restraint rather than just formal legal boundaries. When executive branch officials challenge judicial independence through misconduct complaints, it tests the resilience of American constitutional structure. The broader implications extend beyond this specific case to questions about how democratic institutions maintain independence while remaining accountable to constitutional principles and public oversight. Thanks for watching Politics and Economy USA. These constitutional separation issues affect the fundamental structure of American democracy. If this analysis of judicial independence and executive authority helped you understand these crucial institutional dynamics, subscribe and hit that notification bell for more constitutional and governance coverage. What's your perspective on the appropriate balance between judicial independence and executive authority? Share your thoughts in the comments. Understanding these institutional relationships helps us all engage more effectively with constitutional governance. See you next time.